So without further ado, John, Thank you. All right. Well, that was a thrilling, episode here. I'm glad it all worked out. Maybe I should go into business or technology, right? More complicated than what I do. So I am a management side labor and employment lawyer, right? So that means I spend my days doing two things, really. Keeping companies out of trouble with their employees, legal trouble, and then helping companies resolve legal problems with their employees, right? Most of those are lawsuits, so by resolve them, I defend them in the lawsuit. So what we're doing here today is the first part of that, right? It's trying to avoid the legal problems, right, and the distraction and the costs that come with employment lawsuits. So our agenda today, right, we're talking about just for a minute, a little bit more about why we're here. We're going to talk about claims for leave and disability laws. That's a really hot issue right now and very attractive to plaintiffs' counsel. We're going to talk about our workplace violence policy here at the bank. There's a lot of, that's getting a ton of attention, right? I mean, you cannot turn around without some other workplace, school kind of incident. And so this is something we all as a manager all need to be aware of. We're going to talk about the wage laws and how claims come from there. And then there's actually this very new hot topic that we're doing a lot of training on, which is this idea of this law that was created for unions called the National Labor Relations Act. But there's an implication or an application. The application to non-unionized employers that you'll see is really generated by the use of social media, which has created in the last 5 years quite an issue for employers. So if you have any questions as we go along, please just raise your hand or shout out or whatever, that's fine. I'll make sure we get all through the content. Despite the fact that I lost 7 minutes, I'll get us out of here on time, right? All right, so why are we here? It's a quiz. So who thinks we're here to discuss policies that are somebody else's job to enforce? Raise your hand. Anyone? One person in the back. Okay. B, who thinks we're here to go over a bunch of rules that impede your ability to get your job done? Who thinks that? All right, at least nobody's willing to guess that's the right answer if you even think it. And then C, we help you be a more successful manager here at the bank, right? All right, C, right? That's the point of this. I think the title for this is like HR law compliance training. I'm never going to use that word other than tell you I'm not going to use that word, compliance, right? Because compliance is really not your job. Well, if you're a bank, you have a lot of compliance obligations. The HR compliance side of it is not one of them, right, for you individually. And that's really boring, and you're not going to do it. That's what we've learned in 30 years of training on, managers don't break this rule, follow that policy. It's that it's a burden, and they feel like it's not their job to enforce those rules. They feel like it impedes their ability to get their job done, and so they don't do it, right? So we're not going to talk about compliance for compliance sake. We're also not, by the way, going to talk about right and wrong, or even, for that matter, much of legal and illegal. And we're not going to talk about right and wrong, because if you need to get your moral guidance from a lawyer from Washington, D.C., you've got a lot of other problems that we're not going to resolve in the next hour and 20 minutes. So it really is about business, right? Every lawsuit is a business decision, right? Every claim, every time somebody demands something, you get a letter from an attorney saying, my client was fired by your bank and it violated his or her rights under this statute. That is a request for what? It's for money. It's about business, right? There's some emotional things that kind of generate it sometimes, but the bottom line, this is all about business, right? You're not here to turn your employees into better people the way you would your children or something, right? You're here to run a business, and this is about, and this training is about business. So these are pretty obvious questions, right? If you can, as a manager, take a few minutes to avoid $150,000 liability, maybe an $800,000 liability, but you don't do that because you're focused on other things, you don't pay attention to these rules, that's really not being a good manager. It's really hard to say, well, look, you did a really good job on the substantive part of your job, but we got sued for $800,000 that we lost because you didn't pay attention to this problem, solve it in a 40 minutes of your attention, so here's your bonus, right? I mean, you know, it's all part of what it means to be a good manager, so avoid these things. And so just look at some of the costs of these employment lawsuits. So let's go through this real quick. Defense fees you pay your attorney. So let's just say one person sues the bank, and that case goes to trial like right across the street here, right? Single plaintiff case, not a class action, also plaintiff, goes to trial, and it's a discrimination lawsuit. You fire him because fill in protected category. What do you think it would cost in defense fees to win that case in a trial? What do you think? Ballpark, somebody.
$25,000.
$25,000. I got 4 kids to go through college. $25,000.
Guess I'm on the low side.
Yeah. Bite your tongue. In that case, which takes about 14 months to wind its way through the court system, would be a minimum of $150,000 to trial, right? Well, it's about 400 or 500 hours of work over that period of time, right, for usually a partner and associate, and you know, they make their bill of rates and blend them up and put into that kind of, right, and that's a minimum. Some cases cost a lot more if they're experts, or I had a case one time, plaintiff's counsel took 26 depositions in a single plaintiff case. That's a lot of depositions. That's a lot of time to defend those, right? There are not even 26 people in this room right now. Imagine, so everybody here plus another 12 people or something, right? So this is an expensive. That's if you win. That's if you just open the door and allow the case to be filed because you don't do the things we talk about today, at least in these areas. That's if we go and we win, right? If we lose, all right, back pay. That's somebody gets fired from here. Let's say they make $60,000 a year. The next job they get it in 6 months, and they make $40,000 in that job. And so you do a calculation, and you arrive at back pay, you know, in a year or 2 years' time by the time the trial happens, some termination of trial. You're looking at a number often. Sometimes it's 50 or 60,000. Sometimes it's 200,000. Let's just say, for our sake of our discussion, we are at $100,000 in back pay. So 150 and 100, right? Somebody here's got to be good with numbers. It is a bank, right? So that's $250,000 where we are right now. Front pay. Front pay is to say, well, look, as of the date of this trial, I earn $20,000 less in my new job. I'm 45 years old. I'm planning on working for the next 20 years. And an expert comes in and says, well, you know, that number's going to spread over time based on raises and percentage increases and bonuses, and so the amount they're actually going to lose is X, and do a present value calculation, and it's always the biggest number in the case. It's a huge number up on the board. They have some guy with a bunch of initials after his name, just put it up there, right? So, but let's be really conservative here, and let's say the front pay amount is just another $100,000. I've never seen a front pay claim that small, right? But let's just say it's only $100,000, so that's $350,000, right? So emotional damages. This is, you made me feel bad by firing me and all these terrible, horrible things you did and said to me while I still worked there, right? And so now you have to compensate me for that emotional damage. So I can't sleep at night, right? And I'm feeling a lot of stress, and I'm not nice to my family anymore. And a psychiatrist comes in and says, he's got a dissociative disorder now. I definitely get that, right? So I was in a case one time in Virginia Beach where there was an emotional damages component. And the plaintiff was a beautiful young woman, 25 years old. She worked for a dermatologist's office, so he gave her all these like free treatments, right? Now the defendant, so she looked like a porcelain doll, right? And her, we thought we were really in this case. Thought we were going to win it. It was a tough case. Her hockey player husband gets on the witness stand to testify about the emotional damage, right? And he testifies that since he's been fired, it's been 2 years since he and his wife have had marital relations, right? A part of turns to me, it says, we're effed, right? That's the way that case went. That was the one loss that I've ever had in a trial, right? Emotional damages. So let's just say here, some laws cap emotional damages at $300,000. Cap them. Some laws, Maryland and D.C., we don't cap them at all, but some laws do. Let's just say another $100,000 for emotional damage. That's $450 we're at. Right? Punitive damages, that's to punish you so you never do this again. Around here, a typical, an acceptable punitive damages ratio is 8-to-1 over emotional damages. So if you had $100,000 in emotional, jury could award up to $800,000 in punitives, right? That's kind of a, if they go to 20-to-1, $2 million in punitives, something that would be unreasonable, but 8-to-1 is pretty reasonable. But let's just say, once again, because I like you and being conservative, that it's just $100,000, another 100 for punitive damages, $550,000. And now, this is the best part. Almost every law we're going to talk about today, if not every law we're going to talk about today, right? If you lose, right, if the defendant loses, not the other way around, but if the defendant, if the employer loses, they have to pay the plaintiff's attorney's fees, all right? And I will guarantee you the $150,000 that I'm going to charge you is going to seem like a bargain when you look at what that plaintiff's petition gets in there, right? We won a case in D.C. They were asking for millions of dollars. The jury gave her $4,500, and the judge awarded them $263,000 in attorney's fees, which we're like, yay, we won, right? Which we since had knocked down dramatically over time on appeal, right? But that was a shocking thing. So, but let's just say this is a win. We're throwing some other money in there. I've never seen a fee petition for less than $250. I've seen them for a lot more, but let's just say $250 is the number. That's $800,000, right? And we were kind of going low on every single one of those. This is real money we're talking about, and it all focuses on the manager. Every case is good or bad, not because of some written policy, sometimes because of what HR does, but 90% of the time, the key is how the manager behaves, the manager says and does. Okay, so you're going to see, we're going to talk about this. 95% of these claims are avoidable. And 100% of the time, even if you can't avoid the claim, once in a while you get struck by lightning. You run into a terrible employee, it's like getting bitten by a shark, right? Most of the fish are nice, and there you were in Acapulco one day and you get bitten by a shark. You're like, why me? That happens. There are employees out there who are just going to lie and cheat and steal, and if you run into one of them, they're going to manipulate things you say and bring a lawsuit. You can't do anything about that. But even in those, that's maybe 5% of the claims you see. But even in those situations when that happens, a manager is on top of things and thoughtful and paying attention to what's happening to him or her and follows the rules and sets a good example and all those kinds of things, helps the claim, even if we can't totally avoid it. So that's why we're here today, right? Not to just jam more compliance and policies down your throat. Okay, so let's talk about two of these really, really hot issues, kind of combining them, which is leave and disability loss, right? This is when an employee says, I'm sick, or a family member is sick, and then usually the add false to that is, I need my job to change in some way, or I need time off of work, right? That's so leave and disability, right? That's where that comes from. But it's all, and frankly, with an aging workforce, you're seeing much more of this. Okay, so let's talk first the Family and Medical Leave Act. We're going to go over the basics kind of really quickly, not so you can administer the FMLA, that's not your job, so you have no idea what's happening, right? So you have what I'll call like a light bulb moment. Things will go off in your head and you'll say, wait a minute, this sounds like you're requesting some kind of medical leave. Maybe I should go tell somebody in the Human Resource Department. Just that level of kind of awareness, right? So the FMLA allows a person to take leave from work. But the whole key, right, to this leave, for these certain reasons, is they get their job back, right? It's not much leave. It's not really granting the benefit. It's say, yeah, you can take 12 weeks off. When you come back, your job may not be here. You're not really giving them very much to that situation, right? The whole purpose of the law is when their leave is over, they're allowed to come back to work if their leave was for certain reasons. And then, well, we're not going to spend much time on this at all, there's also this military service issue, which you see very rarely. But somebody needs time off of work because a member of their family was called up to active duty, right? My wife was called to active duty, so now I need to go meet with the teacher, I need to meet with the bank and figure this out, I have to go to her going away ceremony, all that kind of stuff, right? We're not going to spend much time on that. That one's pretty rare. But the FMLA stuff is very, very common. All right, so the eligible employees are able to take 12 weeks of leave every 12-month period. They get their health insurance during this period, and like I said before, getting their job back is the whole key, right? Okay, so that's the real basics. 12 weeks in a 12-month period. Companies can determine what a 12-month period is different ways. I don't know how you guys do it. Some companies will say January 1, December 31. Some companies will base it on like an anniversary date for a particular employee, so it's different for each employee. And some companies do it on a rolling basis, which is actually the best basis because anytime you put a hard date on it, they get to use 12 weeks right before that hard date, right? So October, November, December. And then if January 1 you refresh, you get 12 more weeks, January, February, March, right? But if you did a rolling year, you wouldn't get that, right? So I'm not sure what our policy is. Okay, so the reasons for FMLA. Child's placed in the home, right? Whether it's by birth, foster care, adoption, anything like that. That is a reason. We call it sometimes maternity or paternity leave. But when people talk about taking maternity and paternity, they're talking about taking family leave under the FMLA. That's what that term means, right? Okay. Or to care for a spouse, son, daughter, or parent with a serious health condition, we'll talk what that term means just briefly, or to care for the employee's own serious health condition. So my son has asthma. He needs to miss time from work. My wife has, name an illness. My father's got whatever. I'm able to miss work to care for them, right, because of that illness. Or if I've got a serious illness like that, I can miss work to care for myself, right? Remember, any questions, just shoot your hands up and ask them. So these are the basic reasons for leave. Okay, we'll talk more about sort of what manager's role is here in a minute. All right, so the key here, right, is that when an employee were to tell a manager they're going to miss work for a reason that's covered by the FMLA, they are putting the employer on notice that they're requesting FMLA leave. Makes sense, right? The problem is, where we see a disconnect, is that the managers don't always realize that's what the employee is doing. So your employee tells you, hey, look, I need to miss work, right? Not because of any magic words, or use the word FMLA, but I need to miss work. My husband is having back surgery. He's going to be really incapacitated. I need to miss work for a couple of weeks, right? The light bulb needs to go off. This employee is requesting FMLA leave, right? So you need to say to that person, this is covered by our FMLA policy. You need to talk to the HR department, right? As opposed to just saying something like, no, you can't do that. You don't have any vacation time. Or, yes, you can, but then nobody else knows about it, and you write in their evaluation, you didn't get the so-and-so project done that fit with those 2 weeks, right, that they were out. I mean, it's protected leave status. So where we get into trouble as managers is when someone puts us, the employer, you are the employer, on notice of this leave, and we as managers don't direct them down the right path, right? Okay, so the reasons for, when you hear somebody say to you, I need to go, me or a family member are going to be surgery, we're going to go to the hospital. It's anything related to a pregnancy, including things like bed rest, right? So not just the birth of the child, but the pre-birth of the child, right? Somebody is missing time, right, for somebody's chronic illness. Military we talked about, or any illness that lasts more than 3 days. So if somebody says, I'm sick and I can't come to work, and now we're at day 4, we're on day 5, that's when you let the HR department know so they can get them this FMLA paperwork that they need to fill out, and we can take the steps we need to take. Or somebody is coming, sorry I'm late today, my son's asthma was acting up. The next day, I can't come in today, the pollen count's really high, my son's asthma was bothering him. 3 days later, same thing. Once you hit like a relatively small number of these events related to the same illness, you've got what's called a chronic condition, and we have to get HR involved, right? How many people can think of a time, you'll give me an example, where you've been aware of this kind of condition and you've just kind of let it, you haven't done anything about it because you're a bad person, just because you didn't know or you weren't thinking in terms of this leave. Is anyone in this room fall into that category? No. All right, well, then you're the first, congratulations, you're the first group that's never had that situation. Most managers, and most lawsuits that flow from this is exactly this fact pattern, right? I'm going to miss work because this asthma, my kid, all of a sudden, managers in HR's office 5 months later saying the employee's got a tardiness problem, right? They're not here enough. They didn't make the link to the FMLA piece of protected leave. Yeah.
Do addictions or substance abuse problems, are they a subset of FMLA? Is that
Well, in terms of substances, alcoholism is a disability under the ADA, and so that generally does become a serious health condition that we're talking about now. Illegal drug use is not. Right? Yes?
So if you have a chronic situation and it doesn't exceed 3 days, that still falls under.
Mm-hmm. Doesn't exceed 3 days in a row, right? So if I'm out for more than 3 days because of a one-time thing, but it lasts 4 or 5 days, that's definitely protected. And if I miss an afternoon, a morning, the next week I miss a day, the week after that I miss a morning, never 3 days in a row, but chronic, right? That's also FMLA.
When does it consider to become chronic, though?
Really, it's any time an employee is missing time for the same condition. So, in other words, the rule is if the person's got an underlying condition that has a tendency to flare up and flare down, right, then it is an FMLA condition. So you can, some of them are very, very serious, you know, lupus, epilepsy, cancer, right, these kinds of things, diabetes. Some of them are more minor and are migraines, which can be very debilitating, right, but aren't life-threatening like some other ones. And we can, asthma is another one, right, controllable, but, so there's all these kinds of conditions. And so it's, the answer is that as a practical matter, if an employee misses very little time because of these conditions, we as managers don't really care, right? They've got some sick leave, if they've got asthma themselves and it's a day in the fall and a day in the spring, who cares, right? But a good rule of thumb, although it technically still is FMLA covered if you wanted to go through that process, but a good rule of thumb is if an employee misses maybe more than 3 days in a month, or has 3 tardies and absences in a month for the same chronic condition, for themselves or a family member, that's the time the bell needs to go off in your head and you need to let the HR department know.
What if they don't tell you why?
Well, if they're just missing time, right?
Ask them.
Well, what I would do in that situation is, first of all, it's very rare for you to have no idea when an employee is missing time if it's in a chronic situation. It happens, but usually word sort of filters around. But if you really don't know, but you suspect it's the same condition, then you should go to HR, and what we essentially do in that situation is give the employee the paperwork and let them be the ones to say, no, I'm not going to fill it out, or to fill it out and say, this is not FMLA covered. So we should not ask them as managers, but we should recognize that we don't know as potential FMLA and go to the HR department. Make sense? Okay. So never talk, very simple rule, never talk to an employee's doctor. They want you to talk to the doctor, they hand you a note. This all happens by HR, right? You don't need these headaches. It's not your job. Any paperwork you're given, it's like, you know, it's kryptonite, you're Superman. Be like, go give that to the HR department. You don't need to touch it, right? It's not your job, and only bad things can happen. So we're just going to walk through this bad situation one time so we can all understand it real clearly, right? Employees, intermittent chronic absence are becoming a concern. You know, or maybe the employee would say you know, even if you really don't, it's got some kind of chronic FMLA issue, chronic employee illness, sick child. You want to support the employee and say, look, just take your sick leave, you know, you're a good employee. But eventually, something happens. You have a customer that's a problem, a vendor that's a problem, your life is more difficult, something spurs this, and you go to HR and say, hey, John's got an attendance problem, I can't take it anymore, we're not getting things done. When that happens, we have not hit any of the required deadlines for giving employees lots of forms. We haven't gotten information from them. We haven't provided them with their rights. There's like 4 pieces of paperwork that go back and forth here. And we've done none of that, despite the fact that we've been aware of the FMLA condition because you've been aware of it. So we find ourselves in this wonderful little scenario where the employee's leave they've already taken is protected, but we cannot count it towards the 12 weeks. So if they've missed a total of 6 weeks, and you've tolerated this, they are starting at day 1, the day after you walk into HR, not at day 31, right, out of 12 weeks. So, and that's going to make you be like, oh, I'm so frustrated by this. You know, why did I look at an attorney who came in here, right? I mean, literally, you get mad at Kia. You'll get mad at me if I get a vote with you. You'll get mad at everybody who tells you to do about it, but this is it, right? You know, this is how you avoid it. Right? And all you got to do is send a 30-second email to HR. Hey, John's missing a lot of time lately. I think it's FMLA covered. Please do your thing. And it's no longer your problem. Like that. Okay. So what are the takeaways? When you see these things, let HR know. Employees absent for more than 3 days. Chronic absence for a health reason, theirs or the employee. Right? A regular course of treatment. Physical therapy, right? It's like, you know, I tore my Achilles tendon, I got to have physical therapy, it's very minor. Can be a mental or emotional treatment, like psychotherapy. Can be something very serious like cancer or chemotherapy or dialysis, right? Right? Any of these things to care for a family member, anything that's pregnancy related, right? So, yeah, if someone goes for an ultrasound, this is the morning, testing that's FMLA, we usually don't worry about that. But they're on bed rest, right? Now we definitely worry about that one. Okay. So, the other pitfall is retaliatory comments. Somebody tells you they want to take leave, you have a negative reaction to it. They come back from a leave, you have a negative reaction to that. You put something in performance evaluation. I once saw a performance evaluation, meets expectations, right? In the writing, would have gotten exceeds expectations had he been here the whole year, right? that is retaliation for taking FMLA leave. So it's like those 12 weeks, 6 weeks, whatever the block of time is, it's like they didn't happen when you evaluate the employee. And so think about the negative comment. So I tell you I'm going to go on leave. You tell me, oh, that's just perfect. You know, it's our busiest time of year. You're really letting us down. I can't believe you're doing this to me. You know, fine, do what you have to do. Okay, I go, I take my 8 weeks. I come back. 4 weeks later, I and the other 2 people in the department apply for the same promotion. I don't get it, right? I say, I didn't get that because I took FMLA leave. That's unlawful retaliation. Oh, yeah, what's your evidence? Well, when I first told you that I was taking leave, you said, how can you let us down this way? You're not a team player, and you're upset with me. All right? That's pretty much all a plaintiff's attorney needs to bring that lawsuit. So we've got to be very thoughtful about what we say, right, and what these rights of these employees are. Right about now, people start getting kind of annoyed, and sometimes that annoyance is directed towards me, right, which is fine. I can take it. But realize this. I didn't create these rules, right? I'm just explaining to you what the rules of the game are, the game that you are forced to play to have this job, right? And so, you know, having sort of an emotional reaction, some people do that towards me, like, I'm fine, that's all right, but realize you can't reject this. You can't be like, this is all a bunch of BS, I'm not going to do this, right? Because that's how people just walk chin first into probably one of the worst things that's going to happen in their career, frankly, right, is to be embroiled in one of these things. All right, let's talk about the other side of this, the ADA. Look at the increase in charges filed claiming disability. The EEOC, you can file charges for any kind of discrimination, race, gender, age, religion, all kinds of harassment claims, retaliation claims. So we've seen a significant increase in ADA claims in both the raw number and in the percentage, right, of charges filed. So this is another hot area, people who claim they have disabilities. So disability is basically an impairment that impacts a major life activity. When George Bush signed the Americans with Disabilities Amendments Act, the ADAAA, the definition of disability went from about 3% of the working population to about 75% of the working population. So 12 people, 9 of you have disabilities under the ADA, right? I mean, that's about what it would be. So we used to win all the lawsuits on saying that person doesn't have a disability. So we didn't have to accommodate them. We could discriminate against them. They don't even get in the door. Now we don't even make that argument since the end of 2008 when that law was signed, right? Don't even make that argument anymore. Okay. It's not the same thing as Social Security disability, just so you know. And pregnancy is never a disability because when my wife with 4 kids might disagree with this, it is not a permanent condition, right? Disabilities must be permanent or long-term. They cannot be short-term conditions. So you break your leg, that's actually not a disability because 6 weeks later you're going to be okay, right? That might be an FMLA issue, but it is not a disability. Disability would be like you break your leg and now you're going to limp forever. Now you've got a disability, right? Okay. So what do we have to do? Well, first of all, we can't discriminate against these people. We all know that. Second, and this is where managers have problems sometimes, we have to provide them with reasonable accommodations that allow them to perform the essential functions of their job. And I highlight also the word interactive process because this is where you come into play, right? So in other words, to comply with the ADA, unlike FMLA where all you've got to do is have a light bulb go off and let your HR director know, in the ADA, we want our light bulb to go off. We'll talk about that. But then a little bit more is required of you. You need to actually participate in the accommodation process. There's 3 people who get involved in that process. HR, who kind of knows the policy and how it works, the employee who makes the request, and the manager who can tell HR and the employee if that request makes sense or if there's another way to solve the problem that's easier on the operations and the department, right? HR cannot make those kinds of calls. They have to have the substantive knowledge of what's happening in the department to make those calls. Okay. So what's the trigger? An employee wants some kind of change in his or her job due to some kind of medical condition. So I need to work at home. I can't work a full day anymore. I can't concentrate. I need to have a bigger screen. I'm having a problem seeing my screen, or you name it, right? Now, some of these things we're going to reject because they're unreasonable, and we'll talk about that whole process. But as soon as they ask for something, I could do my job. You know, you have a performance evaluation meeting, right? Tell them, you're not doing your job well. You're not succeeding here. If you keep performing like this, you're going to get fired, right? well, I've got this medical issue, and if I was able to do X, Y, and Z, or just X, we wouldn't be having this discussion because I would be doing well on my job. That is a request for accommodation. Just like FMLA, no magic words. They don't need to say accommodation or ADA or disability or any of that. So, and you know, this is a quote from the EOC, but when a reasonable accommodation, simply put, is where you do your job, when you do your job, and how you do your job. It is not what your job is. That's not a reasonable accommodation, right? So that's unreasonable. We're not going to do that. So we had a guy who had very serious kidney problems, was on all this medication. The medication made him fall asleep sort of uncontrollably. All right, well, maybe if he was working at a desk and he could get his 8 hours of work done in 12 hours, maybe extend the time for him to do his work, we can accommodate that, right? I mean, it's not maybe pleasant to see somebody fall asleep at their desk for 20 minutes, but it's not the end of the world. Unfortunately, he was a forklift operator, right? Can't accommodate that, right? I mean, okay, so my point is, like, there's a degree of reasonableness that goes in here, but, and maybe in that case, HR didn't need to ask the manager, well, is there some way to accommodate a forklift operator who continually passes out? Like, the answer to that pretty obviously is no. But I mean, you can imagine jobs, that's a pretty unique case, right, passing out like that. Okay, so what don't we do? We don't change the job, right? We don't say people can be poor performers. It's not a reasonable accommodation for somebody to say, I just want to do this job worse. Like, I'm here 8 hours, my work product just stinks, and just give me a break on that. I actually ask that all the time. Well, I'm just not very good because I can't focus. Well, maybe we give them a leave of absence under the FMLA to get their act together. But we don't say to them, yeah, keep doing poor work product. That's not a reasonable accommodation. We don't excuse misconduct. There are a lot of cases of emotional disabilities, mental disability. People threaten other people, they swear at them, they scream at them, they get maybe even physical violence. They don't take any of that, right? They swear at a customer or a bag teller who has Tourette's, but we can't accommodate that, right? Because people aren't going to come in this bank anymore if we have that, right? So, I mean, you don't have to accept misconduct. We don't have to give people a stress-free environment. We don't get to change workplaces. We don't get to bump somebody else from a job, and we don't have to create a new job. Now, we will sometimes transfer someone to an open position for which they're otherwise qualified and they can do with their disability. That's not creating a new job. That's just transferring jobs to an open one. But we don't make work, and we don't hurt anybody else's job, right? So there are some pretty strict limits. But this is where you come in, right? So it's like, by the way, so it is a separate violation of the law to not engage in the interactive process. So in other words, somebody will say, look, I need an accommodation, and I need to take really long breaks throughout the day. Like, I can't stand enough. And we say, let's pretend they're a bank teller. So, well, look, we're only open. When a bank's open from like 11:45 to 12 o'clock? Sometime around there, no, right? So look, our bank is open from 9 to 5, right? And you can't have this job and need 3 one-hour breaks of the day, right? You can do it, but then you've got to hire someone else to take your slot. I mean, we can't accommodate that schedule because we're only open, it's a customer-facing job. We're only open a certain amount of time. If we were to say, so that's your request, HR talks to you, you say, no, we can't do it. Sorry, you're turned down. We can't do that accommodation. We have just violated the law because we have not engaged in any kind of interactive process. The interactive process is you and Kia and this employee sit down in a conference room, say, look, you've asked us for a break from 10 to 11, from 1 to 2, and from 3 to 4. This is why we can't do that. But what's the issue? What do you really need? What if we did this? What if we did that? What if we got you a stool to sit down on? What if we allowed you to take a 15-minute break and then ended your day 20 minutes? Who knows, right? But what if you had this conversation? Would that work? Well, maybe, but now you're engaged in the interactive process, right? Then you could try it for a while. We'll just try this for 2 weeks. Let's have another meeting and see where we are. Try for 2 weeks. If you are, is it working? Well, it's not working for you, but it's working for them, or vice versa. Change it again. That's the interactive process. The law requires you to engage it. You can't just say no. Now, how ridiculous the request is, you cannot just say no. And the manager must be part of this process. Here are the steps for the interactive process. And, I mean, first of all, not only is HR unable to do all these 4 things by themselves, you don't want them doing it. You really want HR to decide what the employee's essential job functions are for you, figure out what the limitations are, think about it with the employee themselves, and just impose it on you. I wouldn't want that if I was a manager. I manage our office. I wouldn't want that. I want to be part of this process. I'm the one who's responsible for getting the work done in the department, right? So you have to engage, right? You have to engage. So what are the two ways managers get in trouble? First one is being really nice. An employee comes to you and says, look, I'm having all these fill-in-the-blank problems. I really could use working from home in the afternoons for the next week or two. They really get my act together, or help me rest, and you say, you know what, you're a great employee, fine. I'll let you do that. So they do it from week 1, week 2, you're not really paying attention, week 3, week 4, week 5, I see this all the time, and then you come to them and say, look, I'm not sure it's going to work, and they say, why not? It's been great the last 4 weeks, 5 weeks. No, not really. Now you go to HR. Now you're 6 weeks into this thing. And the question is, well, why is week 7 different than in week 1? Why could you tolerate it? And the answer is, you violated some of these really essential rules about reasonable accommodation. Person's not doing their job functions. They're not meeting their productivity standards, right? We've given them new duties and essentially created a new job for them in some ways. And you're just doing this stuff to be nice. Now, sometimes we will give people what is really an unreasonable accommodation for a very short period of time because we do want to help them out and we do want to get them through this, but we will document the hell out of that. This is totally a burden on us. You are not doing your job. We're only giving this for 2 weeks, and then we're taking it away. You will not do your job for these 2 weeks. Merely by the grace of me am I giving this to you, right? And that's how we kind of put it. But, 3 months later, you're in a tough situation, and really it's you break it, you bought it. We can't help you. So that's number one. Number one way to get in trouble. The other side of it is being mean. An employee comes to you and says, look, I need to work from home 3 days a week. Because just for a short period of time, this is the kind of, I have a data entry job, whatever it is, there's a reason they can do it. You can make it work. Maybe this time of year they can make it work, or with the work that's in the department right now, and you just say, no, nobody works from home. Sorry, can't do it ever, right? Really the opposite side of the same coin you were in before, right? Now you're not in the accommodation. They failed their job. You start counseling performance. Maybe you fire them. And the first HR hears about it is when they get the letter from the attorney. And now, by the way, nothing's documented. Whatever they asked you for is what they say they asked you for. And you're going to say, no, that wasn't the conversation. That's totally up in the air, right? There's no documentation about any of that. And we're in a real mess. So don't be nice. Don't be mean, right? Just follow the rules. The rules are when somebody says, I've got a problem and it's medically related, it's impacting my job, go right away to the HR department, all right? One other thing. We never want to raise in a performance evaluation the possibility that it's medically related. Let them raise that, right? We never want to say to the person, well, it's because you're, borderline bipolar that we're having these problems, right? I mean, you laugh. This is what happens, right? People say this kind of stuff, right? Just you stick to performance. Let them say, hey, I've got a medical issue, I need help, and then we can deal with that fairly, honestly, and follow the law and everything else. But make sure that they say, right? And we've already gone over all the things you need to do in the interactive process. I would talk about a related issue. We talked about that. Okay, so related issue is working from home. FMLA meets ADA. People get very confused about this, and they kind of leverage themselves into more rights than they're allowed to. The FMLA does not allow you to work from home. People say, my spouse is sick. My wife just had a baby. It's a baby. I want to work from home. I just had a baby. I want to work from home. People confuse FMLA and ADA. FMLA, you're either on leave or you're working. Those are your two choices, not working under your circumstances. So you don't have to agree to any of that. And the person says, because of my own medical issue, I want to work from home, then you assess it as an ADA issue, and then maybe they get FMLA leave if you deny that accommodation. But there's no right under the ADA, right, to care for another person to work from home, and there's no right under the FMLA to work from home for any period of time at all. It's either about taking leave or being at work, right? So this is a common mistake that a lot of companies make, is that they confuse these two things and they let people work from home for FMLA reasons where it's not really allowed. Another related issue is our workplace violence policy. You guys have a pretty big handbook, and it's like single space, right? So what that usually means is that nobody ever read it, or if you had read it, you don't retain it at all, right? I mean, that's what happens. So this is the actual words from your workplace violence policy. Why is this so important? It's so important because in that case, when the employee comes back to work and hurt somebody, or they followed that female coworker home and hurt her at her house, right? The victims of that look for somebody to sue. Maybe it's a reasonable reaction, unreasonable, but it's the reaction. And they're not going to sue the person who just got committed to a mental institution or going to jail. There's no money there, right? So where do they turn? They turn to the employer. You know, they turn to the school system if it was in the school, right? This is where they turn. No matter how horrific or unanticipated the acts are, this is where they look. So we need to take a lot, protect ourselves from this liability and just kind of be aware of some of these things, right? So there's the policy. We prohibit, and look at, I want to point out how broad this is. Acts or threats of violence by any bank employee or former employee against any other employee, right, in or about the bank's facilities or elsewhere. That means anywhere in the world. I mean, either in this bank or anywhere else. That means anywhere else, right? At any time. What does that mean? That means one of your coworkers makes a threat at night on Facebook to one of your other coworkers and violates that policy, and now it's our problem. The biggest mistake we make sometimes is saying, hey, that's personal. That's outside of work. That's not our problem. Our policy makes it our problem, right? The bank also will not condone any acts of violence against bank's employees, customers, or visitors at the bank's premises or any time, or they engage in any business anywhere. This second clause is a little more limited. It's not just an employee-employee issue, right? Now we're dealing kind of third parties. But really the key for us managers is that first clause. And basically, we have to, police is the wrong word, be aware of employee behavior that's brought to our attention, even if it's purely personal and totally outside of work, if you would call it a threat or act of violence. And there's a reporting mechanism, right? Any reports of violence have to be promptly and thoroughly investigated and appropriate action taken. Any bank employee who violates this policy so we can discipline. Now, if you notice there, it doesn't say all reports must go to the HR department or must go to the general counsel or whatever. It just says any reports. That means it can go to you. So, very simply, right, what are some of the takeaways? Location and timing do not matter. So we never want to say, hey, that's really, we had a case one time where, this is a great fact pattern, a project manager had dated the receptionist, right? And then he was dating, that broke up, now he's dating somebody else who worked in this company, right? So we had like a love triangle in the company. Never, right? Good for me, as a lawyer, like the soft is off the street, not good for the company. So the two women found out about this, they were very jealous of each other, and all this crazy stuff was happening. And one day, the receptionist walks in with a printout of a Facebook post and hands it to the HR director and says, I can't work here anymore, right? And there's a Facebook post, and there's a picture of the other employee. There's her little face in the top left-hand corner, followed by like a full page of some of the most like revolting, kind of weird, threatening stuff like you've ever seen, right? And I actually get to look at a lot of this stuff for my job. It's like one of the perks, right? And I mean, it was like I was 8 miles away in my office, and I got freaked out when I read this thing, right? It was like, what about? It was just so bizarre and freaky, and HR's first thought was, well, what do we, is this our problem? The answer is, I mean, they're policy like you guys. Yeah, it's your problem now, right? This person hurts this other person, so what's the link? The link is, we went to the woman who sent the note, and we said, did you send this? She confirmed, yeah, that's me. She said, well, what do you care? So all we care is we've got another employee here, right, who is afraid to come to work because of what you're doing. Really, the way you look at it is her behavior outside of work is making us choose between these two employees. And we said to her, and because you're the one who's engaging in behavior that's, borderline psychotic, frankly, right, we're going to choose her and fire you. If you ever do anything in our reasonable estimation that makes her sort of rightfully fearful to come to work, right? So, if you say hi to her in the parking lot and she comes and says, I'm afraid to come to work, not reasonable. But you send her something like this again, you're going to get fired, even though you think it's only personal and outside of work, right? So that is the kind of...
So you have to give them a second chance when you...
Well, you don't have to give them a second chance, but it wasn't like, I'm going to slit your throat kind of threat, right? If something like that, you'd be like, whoa, we're probably going to fire you right now. Just sort of bizarre kind of stuff, and we felt it appropriate to give a second chance because it was all wrapped up in this sort of romantic issue. Yes?
So are you saying that because our policy is written so generally, or even if we didn't have a policy, this would apply?
Well, I'm saying that there's no doubt about this, the way your policy is written. And even still, if an employee, well, the question is, I mean, let's think of the example I just gave you, right? There's only two options when an employee comes to you and says, I'm being threatened by another employee outside of work. Option number one is to do something about it, tell the employee to stop, and then fire them if they don't. Option number two is to ignore it and say it's personal, right? That's not a particularly good option because, once again, they are going to say, I asked my employer to protect me. If something ever happened on your premises, you would get sued, right? They put you on notice, and you didn't do anything. And then the other reason it's not a very good option, is that a good practice? We want our employees threatening each other so that our good employees are, I mean, turns the place into a lunatic asylum, right? Only people who can, stand, threats of physical violence from other employees outside of work can work here because all the normal people have been, like, pushed off by the crazies. Like, we don't want to do that, right? So there's not a lot of options. In other words, even if the policy was written more generally, we didn't have a policy, which would not be a very good practice to have a policy in today's day and age. But even if we did, you would still have to do something in these situations, right? Because there's not a really good option otherwise. Not a very good option otherwise. All right, so, but you know what? A lot of these situations are very, very emotional, right? And very, they really harm reputation. So-and-so threatens somebody else. So we want to be very careful. We don't tell other people about it. We only report it to people who need to know. Maybe your manager, HR, this level of person. We do not want to be, oh, did you hear someone, to your coworkers, right? To even other level managers. So we, once again, protect ourselves from defamation claims, just be factual. This is what this employee said. This is what I ever heard them say, not what your spin on that is. Very important. Write down what you're doing. Right or wrong is determined 100% in hindsight, right? In other words, if somebody comes to you with a threat and you ignore it and it never comes up again, I guess it's no harm, no foul, right? But if someone comes to you and says, look, the guy down the hall is really freaking me out, and you ignore that, and then he sexually assaults her in the parking garage, you were wrong for ignoring it 100% of the time, right? So it's determined by hindsight. It's very hard to argue you were reasonable if you didn't do something and bad things happen, right? So we got to, so that means we need to err on the side of reporting every time, because we don't want to. I mean, I had a situation where one guy was sleeping with another guy's wife, and the guy who was the cuckold or whatever beat the hell. This is at a construction site. Beat the hell out of the other guy. The guy who was gotten beaten up sued us for, right? Negligent retention, negligent supervision, not protecting him on the work site. All right, pretty interesting case actually. But I mean, so this is real world stuff. Yeah.
This is a situation that actually happened at a former employee, and I'm interested to hear your take on it. So, off-site employee event, alcohol's involved. One employee attacks another employee physically. It was an unwise decision, and the employee that was attacked defends himself. They're both fired. Should
Right.
we both be fired for that?
Well, there's probably a lot of details in there about like why they got into the fight and how much they've both been drinking and what level they are in the company. So it's hard to.
And they were at very different levels. The
Yeah.
attacker was very senior.
Right. So.
Seems, but anyway.
Yeah. So maybe the person. Maybe you would say in that situation that probably the person who was the victim, maybe shouldn't have been terminated. But it's not an unreasonable, or maybe it's not an uncommon thing for the company just to be like, look, we're not dealing with this at all. Send a message to everybody, and both of you are fired, right? And when there is a workplace violence incident, especially without a forewarning, you can almost always, if it's not a very, very serious incident, like some kind of shooting or something, you can almost always be very thoughtful, get on the victim's side, protect the victim in a certain way, document certain things to that person, give them a lot of options, really support them, and avoid any kind of lawsuit, right? Avoid any kind of claim. That happens, and I counsel people on that all the time. It's not like because something happens. What we're trying to say here is, though, if somebody had forewarning and they feel like they were ignored, that's going to create the kind of feelings that make somebody want to sue you, right? And our policies tend to prevent that. Okay. Wage and and hour law. There's so many of these wage and hour cases. And now, in some parts of the country, you see very few of these. Texas, Deep South, you don't see a lot of this. We have an office in California that only handles wage and hour violations because it's so prevalent in California. Maryland through Massachusetts, or D.C. through Massachusetts, we're starting to get hit by this tidal wave of these wage and hour cases, right? Just as an example, it's been very popular recently on the East Coast, loan officer cases, right? Where the loan officers are properly classified as exempt or non-exempt. And what does that term, loan officer, mean? Depends on the institution a little bit, right? How much discretion they really have and how they're paid. And this is just one job category. These lawsuits are coming up all over the place. I got a client right now at a fast food restaurant. People are paid by tips. You're allowed to be paid by tips. But if you pay somebody by a tip, you got to explain to them in writing when they're hired, this is why we're paying you less than minimum wage, because your tips are going to make up for it. And the law requires you give them something in writing when they're hired so they understand why they're getting $2.50 an hour instead of $7.25. If you don't give them that writing, you can't take the credit for that tip, meaning you owe them for every hour they work about $5 an hour, right? Not a good situation for us to be in. That's our lawsuit. So it's a very easy case for plaintiff lawyers to bring. They make a lot of money off of it. And we just have to make sure that we're on the right side of these wage and hour issues, even in an industry like a bank where some of the issues aren't so prevalent. Okay, so the basic rule, right, is that everybody is entitled to overtime if they work more than 40 hours in a week. That is the premise. Everybody in this room, including me. That's how you start the conversation. Now, there are certain positions that are exempt from that rule, right? If they meet certain standards and if they're paid on a salary basis, they have the same salary every week, right, no matter how much or how little they work, right? Nothing in there, if you'll notice, is about employer or management discretion. I want to decide to make you exempt. I want to decide to give you a salary. I want to promote you to this position. You can have all the good intentions or bad intentions or whatever they are in the world. It doesn't make any difference if you don't meet that test and you don't pay someone on a salary basis, right? So that is the way that we come at this. So what are some of the basics? Hourly employees, known as non-exempt, which is a double negative, which is a ridiculous term, right? We should just call them hourly employees, right? Are paid for all the time they work, right? Any unpaid time in the state of Maryland entitles them to triple pay. So if I work half an hour overtime, I'm an hourly employee, I work half an hour overtime every day, a little bit here, a little bit there, didn't get paid for it, just got my regular 40 hours a week, even though I worked 40 and a half, right? Did that for 3 years, right? Quickly add that up, that's half an hour a week, 25 hours a year, 3 years, 75 hours you owe me. You would actually owe me for 225 hours in pay, right? Because Maryland triples it. So what seems like a small amount of money in these cases actually escalates pretty quickly into somewhat reasonable amounts. And actually, if you've got more than one employee, it gets very big very fast. Another rule is that salaried employees cannot have partial day deductions from pay. So if you're, remember the rule was you have to be paid on a salary basis. Well, a salary basis means that you cannot have a policy where somebody works 4 hours in a day if they're salaried and gets leave without pay for the rest of the day. There is no leave without pay for a salaried employee. Makes sense? Right? They can take half their vacation or something, use some leave bank, but they can't be unpaid. And anyone who complains about any of this is subject to retaliation, even if they're right or wrong. Right? As long as it's a good faith complaint, hey, look, I think my paycheck is wrong, I think I'm being paid incorrectly, right? They're still entitled to be protected from retaliation, even if it turns out that they're wrong and you're right in how you're paying. Right? So what are the pitfalls from this? So the biggest one is uncompensated, the one that really, not the biggest one, but the one that you guys have the most control over. See, a lot of this, you're not determining the classifications of employees, right? You're not saying who's exempt, who's not exempt. That's HR, legal department, whatever it is, right? These kind of people. But you all impact this, which is someone is an hourly employee and they work uncompensated time. So there's lots of rules. There's dozens of pages of regulations about what's considered compensable time and what's considered non-compensable time. And so as a manager, one of your jobs is to make sure if somebody works, they're getting paid for it, right? Now, what's the problem here? A lot of really good employees will be like, oh, I'll just do it for you, don't worry. And they're your admin assistant, and they'll work till 5:15, an extra 15 minutes, and not put it down, right? And that's just like a sense of loyalty. They don't want to seem petty. They want to seem like they're part of the team. You appreciate that, and it's a violation of the federal law, no doubt about it. Just no doubt about it, right? And so this is how we get lawsuits, right? So people come in early. They're supposed to be here at 9 o'clock, and at 8:40, they're putzing around. They're getting things ready for the day. They're answering email, right? They're kind of getting themselves set up. They're not just coming in, getting a cup of coffee, and BSing in the kitchen for 15 minutes, and then showing up at their desk at 9 o'clock. They're at their desk at 8:40. Absolutely uncompensated time and exposed liability for the bank. No doubt about it. During lunch, right? Same thing. They don't get paid for a half an hour lunch or an hour lunch, right? This is unpaid lunch I'm talking about, right? And for that unpaid lunch, they work, right? They come in, they come back, you ask them to do something, you don't realize they're on the lunch break, whatever. After their shift, so the 15-minute example at the end of the day, all right, I walk down the hall, and I know this secretary is supposed to do it at 5:30, and it's 5:40. I'll be like, what are you doing here? All right? Oh, I'm just finishing something up. Fine, finish it up. Make sure you put down overtime on your timesheet, right? Because otherwise, it violates the federal law. And then nights and weekends, now if someone comes in at night or on a weekend, they'll often get paid. But what if they send 15 emails between Friday night, right, and Monday morning? As an hourly employee. As it adds up, those 15 emails are what, 30 minutes of your time, 40 minutes time, something like that? You get paid for that, right? So this is, you know, a lot of employees, they're here, they're working, they're doing well, have these things happen to them, kind of no harm, no foul. Then they get fired, and they go to a plaintiff's attorney office. And I want to say, look, I think I got fired because of my, pick the category. They want to bring a discrimination claim. Plaintiff's attorney says, well, that's fine, we'll talk about that, but let me have you fill out this questionnaire about how you were paid. I had a client in Maryland here, was a landscaping company, 250 employees, so fairly big. It's not a residential, it's a commercial landscaping company, right? And they had a foreman who was literally the entire company was Latino except for the husband and wife that owned it. They were Caucasian, right? They fire the foreman, not the very top guy, but like these crew leaders. They fire him for stealing bushes, right? They lost all these bushes. They go to the guy's house, and there are all the bushes in front of the guy's house, right? True story. They fire him for stealing the bushes. He goes into the plaintiff's attorney's office, who I know very well, and says, I want to bring a Latino Hispanic discrimination claim. And they're like, but everybody's Hispanic. The guy who replaced you is Hispanic. The guy you replaced, everybody works here is Hispanic. They didn't fire you because you're Hispanic. But fill out this questionnaire. He became the lead plaintiff in a 200-person class action for off-the-clock work. Right? Not this work, not getting paid for the time you work. Because, you know, it's hard to prove to a jury, right, that you're a bigot, that this employer is a bigot. They don't like gay people. They don't like Jews. They don't like Hispanics. That's very hard to prove in today's day and age. A jury's really got to not like you to buy that. But how hard is it for a jury to buy the person got to work 15 minutes before their shift, right? When they've got all of them testifying, yeah, the truck would leave the lot at 9 o'clock. That's when we started getting paid. It was our job to load the trucks up. We would get there at 8:15 every morning, and we'd read the order form. Oh, they want to mulch the Johnson's house or whatever, the corporate, yeah. Put 26 bags of mulch on the thing. Oh, and look, we got to do it. Let's gas the truck up. Okay, now it's 9 o'clock. Now we're ready to go, right? He came to deny it. The company came to deny it, right? Everyone's, I mean, great. So plaintiff's attorneys love it, and triple pay, right? And their attorney's fees, like I said. So, I mean, talk about, this is why these claims are so prevalent, because they're so easy to prove, right? They're so easy to prove.
Is there a restriction to pay in comp time versus dollars?
You're not allowed to pay comp time. Comp time does not exist in the private sector. It exists for the federal government, but not for the private sector. So what does that mean? If somebody works more than 40 hours in a week, right? They got to record all their time in a week. If it's more than 40 hours, they get overtime for that time. So it doesn't mean all of a sudden we got to pay our employees 2 hours overtime each week and it's going to hit our bottom lines and our budgets. No, what it means is we got to manage this issue, right? You got to, if if you see somebody there at 8:20 in the morning and their shift starts at 8:30 every day, you got to stop them from coming in. Some companies have a time system on their computer. You cannot log in more than 2 minutes before your shift starts. You have to leave your desk for your unpaid lunch hour. You can't be there. You get written up if you're sitting at your desk during your unpaid lunch hour, more than 2 minutes on either side of it, right? Some people say, well, it's just de minimis. There's a de minimis rule in the law. Here's what it is. This is the example in the regulations. If you're a clerk in a grocery store and your car is parked in the grocery store parking lot and you're walking to your car and you bend over and pick up a gum wrapper in the parking lot and then put it in the garbage can, you don't get to pay them for that, right? That's de minimis, right? That's pretty small, right? For me, that's only my advanced age here, probably only 2 or 3 minutes to bend over and pick up the piece of paper for that, right? But seriously, right? It's like 10 seconds, 15 seconds a time, some small time like this, right? But sitting on a computer doing emails for 8 minutes, that's compensable. That's a quarter of an hour. You guys probably round, right? Most companies round, right? That means if they're there at 8:52, you owe them a quarter of an hour for that rounded time. So we really need to manage this, all right? The other pitfall is having partial salaries take partial days leave without pay. That's not really a manager issue. It's just the kind of thing where I would say to the room, if that's happening, we got to stop that from happening, right? It's clearly a violation. And then you get an employee that comes to you and says, I'm not getting paid. I'm working 20 minutes at the end of the day and 10 minutes in the morning, or I think I'm really supposed to be hourly and you're paying me salaried, or whatever it is. That's protected just like an FMLA complaint would be protected, or request for reasonable accommodation. You can't get mad at that. Okay. All right. Let's talk. The last thing we're going to talk about, the last few minutes here, is this National Labor Relations Act issue. So this act was from the 1930s. It allowed people to form unions. Before that, they would form them on their own. The companies would come in with the nightsticks, right? I mean, this is like, right, people would kill each other. And so the Congress was like, wait a minute, let's have a system for this, right? And we want to avoid, like, a socialist revolution during the Depression, right? So we allow people to do these kinds of things. Most of the statutes protecting people are from that time period, right? They're pro-worker laws during a time when, frankly, the socialists were getting 20% of the vote in elections. So all of a sudden, minimum wage, occupational safety and health, labor laws. I mean, this is how this all came, right? History of it is very, very interesting. Okay, so employees have a right to engage in concerted activity. That's the term, right? This is activity that is for their mutual aid or protection, right? To help them or protect them in some way. And they have the right to do this, and employers can't stop them. That applies to people who are in a union, who are trying to form a union, and anyone else. It applies to every employee, right? The only exception to this are supervisors, what we call management or managerial employees, right? And so that's people who, a working foreman, it applies to. Somebody that's got the ability to hire and fire. So if you call someone a team lead, they're going to be an employee that these laws apply to. If somebody has the ability to hire and fire really and make right performance evaluations that really impact somebody, then they're going to be a supervisor and the rules won't apply to them. But for everybody else, these rules apply, right? So under this law, some policies are per se unlawful. So there's two kinds of claims an employee can bring. Number one, hey, I was treated badly. I was retaliated against for engaging in concerted activity. They can also say this policy is unlawful, even if it's never even applied. So for instance, a policy that says, right, you can't divulge your salary, right? There's a lot of policies that say that. No discussing salaries, no discussing compensation. That's fine for supervisors and managerial employees. It's not fine. Think about it. If you're going to form a union, one thing you have to talk about is how much you get paid, right? What your benefits are. I mean, obviously, right? So you can't have a rule that says no disclosing raises, no disclosing salaries, right? You can't make a rule like that. You can't have rules that are, no speaking negatively about the company. Show respect, show your loyalty at all times to the company. Anything that's too general like that, think about it. If you needed two employees to get together and say, I hate that supervisor, the pay stinks, and the benefits are worse, right? What should we do about it? If that is violating a policy, having that discussion, policy is unlawful, right? And any behavior by you as a manager that does this is unlawful. Now, other than the salary thing, which is actually a pretty common violation, we usually don't care if employees kibitz amongst themselves and say bad things, as long as they're not, offending anybody or being aggressive or rude about it, right? We don't really care very much. However, as soon as social media started, now employers are starting to care a lot more because it's out there, right? So look, this is not like, Ozzie and Harry in the 1950s. This is like the 1990s, right? Employees didn't interact after work. When they did, they were in small groups or one-on-one, and they just said things to each other, at the local bar, at a softball game, whatever, right? But most of the time, employees went home and everyone they interacted with at work just stayed at work. They didn't have any engagement with them anymore. Not a single one of these is true today, right? What is it? It's like, what is it, 1 billion people, rather, have Facebook accounts? 1 billion people, right? And 75% of people use Facebook at work at least twice a week, I think is the number, right? I mean, these incredible numbers, right? And so, I don't know if you all have Facebook accounts. Let's say, who has a Facebook page? Okay, so actually pretty low. And of those of you who had one, do you have anybody who's Facebook friends from work on that page? All right, right? I bet those numbers are going to be 2 or 3 times higher percentage-wise, right? If you talk to your staff out there, right? Because, people work a lot more than they used to. 2 parents are working. Work is more now work and social are kind of coming together. And so what you have is a lot more opportunity to have those discussions that employers don't like. So let's look at a real case. This woman named Dawn Marie Souza was fired for bashing her boss on Facebook, right? She worked for a company that we actually represented in this case when American Medical Response. So she called her, that's not a duck or dork, right? Okay? And a scumbag on Facebook, right? AMR could have fired her for a lot of reasons. They could have probably called it some kind of like thread. They probably could have called it some kind of like harassment violation or something, right? But instead, they had some broad internet usage policy that said don't speak negatively about the company, including on social media. So they fire her. She files a charge to the National Labor Relations Board. National Labor Relations Board sues AMR, and they won the case at the lower stage, and before it got appealed, they settled, right? And as part of that settlement, it was all based on this overly broad policy, right? So this is happening sort of all the time because employers, a manager doesn't like it when he or she reads something on Facebook that's bad about the company, right? Or another employee tells, usually the managers can see themselves. Usually another employee will come and say, hey, do you know what John posted on Facebook about your department? And so we need to be very careful before we go after an employee, keeping this National Labor Relations Act piece in mind for something they've done on the Internet. We need to make sure we've got a legal policy as a starting point, right? We need to, if AMR had come to us before they fired her, they wouldn't have gotten sued. We would have said, look, here's 2 or 3 policies that are perfectly lawful. Fire her under one of these, or under no policy. Just say, calling your employer, your manager, a dick on Facebook is a reason to get fired. That's a really profane thing to say. We can't have that. It seems if you called them into the office, you're fired. It would have been fine. It was the thoughtless way they went about doing it, right? So I'm not saying we're ceding control to the employees. Let's just say whatever they want about us on Facebook and trash us. I'm not saying that at all. I'm saying, though, before we do something about it, we've got to be thoughtful, right? And as manager, if that manager had come in storming at Dawn Marie Souza and screaming at her about that, and that wouldn't be thoughtful, right? Thoughtful is to keep your cool, go to HR, we've got to get rid of this employee. How do we do it? Let's do it. Let's make sure we do it in a protected legal way, right? So, for anyone who uses social media and you want discipline for them for that, you have to go to HR. Pretty good rule, all right? Don't do it yourself, including get mad at the person. And be thoughtful about your own use of social media. You know how many times, right? We've got, some kind of harassment case or something, and first thing everybody asks for now is preserve your Facebook page, print it out, and give it to us, or give us access to your Facebook page and let us go look at it, right? In these lawsuits, and there's just the most embarrassing, stupid stuff on there, right? That is not protected in any kind of privacy right because it's on Facebook, right? And this doesn't even include like Instagram and all this other stuff, right, that is happening like crazy, that my kids know a lot more about than I do. All right, so that's pretty much it. I said 1:30. Look at that. We're like 4 minutes early or 6 minutes early. So does anyone have any questions about anything that we talked about today, or really anything related to management of employees and how that interacts with the law in any way? All right, Kia, do you have anything to?
No, I think it was a great presentation. Thank all of you for coming. If you do think of questions later, please contact me on there.
All right.
Thank you.
Thanks very much.
Thank you.